care of your food for thought. We also take care of your food for stomach. You should be happy. I started 1 minute earlier just to briefly tell you what's happening in MMA next 2-3 programs, which I do not want any of our members to miss it. I'm audible there now? Yes, good. Let me tell you what's happening on 30th of April. This is a program which is discussed widely in the Supreme Court and in so many instructions were given. I don't take the name of the organization. The subject is ad was making competition healthier. And we really wanted our members to really understand what ad means, and so much of social media publication we do in Instagram, social media, Facebook. So we want to be very careful. We got a very good panel to come and share their thoughts. Manisha Kapoor, she is the CEO of and Secretary General of the Arbitration Standards Council of India. It's a watchdog which really oversees what's happening in all the ad industry. We got Ilango, he is from Draft Ulka, PCB Ulka. Then Shashank Singh, he is the head of marketing from India Cements Limited. And we also have Mr. Nag, is from partner RK Swami Ansa Group. So this is a good one. It's especially for young business people and who really use. It's better to avoid, and it's always better to under promise and over deliver. You know how the people are in deep trouble with the court. So let's not do that. You come and attend this program on 30th. Then on 7th of June, again we have an interesting subject which is relevant to all our members. Opportunities, challenges and opportunities in resilience and infrastructure, financial sector and respect of cyber security. We have Ansaraj Verma, IAS Additional Chief Secretary, also the MD of TIS. We got Vittal Raj, he is a founder, he is a member of International ISACA US and very knowledgeable person. We also have Commander Prakash is a Senior Director of CDAC Chennai. This is happening on 7th of May at MMA Management Center. Then on 9th, we have again an interesting event because a lot of people wanted this. So many amendments have been brought out in the last few years regarding the real estate issues, and we want to know something is changed, something is different valuation, what is the guideline value. It's totally not really clear. So we are getting a specialist with the panel. Aarti is a partner of Shardul Amarchand. She's going to be talking to on navigating changing emerging trends in real estate regulations and impact on the industry. We are also having partner Guerra. We'll have the best of the people we are planning to buy, or you want to advise some of your friends what you learn from MMA. Come and attend this event. It's all happening at 6 o'clock as usual, 6 to 7:30. Then on 15th of May, we have very, very interesting event. Again, I will really urge upon you not to miss this event. Electoral reforms is a bane or boon. Again, we have a very interesting panel. T.S. Krishnamurthy, former Chief Election Commissioner, is there. Trilotan Shastri. I keep walk miles to listen to Mr. Trilotan Shastri. He is a founder of Indian Institute of, he is a former Dean of Indian Institute of Management, Bangalore, and he is also chairman of ADI. ADI is all know Association of Democratic Reforms. Based on their, I think, appeal and rule, the electoral bonds got suspended and much more. And you must listen to him what exactly is happening, whether it's good for the nation, it's not bad. We don't know. You listen to the expert, then you can take your call. On 22nd of May, we have read and grow on the subject. What got you here won't get you there. So again, we got a very good panel. I don't want to take anything for the paucity of time. Then we have on Friday, 7th of June, Embrace the Future, Software Science and Business Transformation. And again, it's a very good speaker. We have Art Sheshai, former Managing Director. He's a chairman of Asia Paints now. Then along with him, we have Gopalakrishnan, former Executive Director of Hindustan Unilever. Then Irish Bhattacharya is author, management consultant, teacher, and again, former senior VP of Unilever. This is only happening number of programs. I want to only tell you few, which you, by any chance, you missed in your inbox, you don't miss them. Coming to today's event, let me warmly welcome all the viewers watching this program live. Mali President MMA is supposed to be here, and unfortunately got stuck in the event and conveyed a sincere thing. He will join us any moment. And let me warmly welcome all the viewers watching this program live in all our channels. As usual, the number flashed on your screen. Please send your questions if you have any. And I only request you to, the focus of the question should be the topic what you are discussing. And keep sending them. We'll put them, and the panel is agreed to respond to all your questions. And today is a great day because when Janil met me a couple of months back, he wanted to, I know this is a subject which is very, very dear to many and which will add a lot of value to our members. That's why we decided to do it right away. And I took the decision to do it that way, and with the committee's support, it's a good decision I took because it's such a passionate team. We interact with quite a number of people and organizations. They're so passionate in doing things, and you're going to listen to the people next few minutes, their input, which will be very, very useful. We also given the program schedule where we given the QR codes of what you really need to know. It's the profile of the speakers, the slides. Every time you keep asking me, this entire slide deck is there available there. Then everything what you want to know a little bit about arbitration will be very, very useful to you. That's why I put in a QR code and given it to you. Now, today is really indeed privilege and great honor for MMA, because let me have the privilege of welcoming Justice V. Ramasubramaniam, former judge of Supreme Court of India and Madras High Court, and he joined us online from Delhi in spite of his very busy commitment. Very warm welcome to you, sir. It is indeed a privilege to have you with us this evening, and we are all eagerly looking forward to your thought-provoking and insightful keynote address. Very warm welcome to you, sir. And I also take this opportunity to welcome the distinguished panel for this evening. We have General Bandari, partner, Raja and Tan, Singapore, then Avinash Pradhan, Ganesh Chandru, partner, Dhruva Associates, Srikant Navle, she is independent arbitrator, Singapore and India, and Bala, deputy head of shipping and international trade, partner, Raja and Tan, Singapore LLP. So we also have a lot of members, advocates, young advocates, people from law college. There are so many of them here, and I know so many of them confirm. I'm quite sure they'll be joining us any moment. It's indeed a pleasure to have you with us. I know this subject will give you a lot of insights. I firmly believe arbitration. You must know what is arbitration to do it at home. I keep doing this between my wife and my children. Every time there's a fight, we do the arbitration, settle it amicably. But when you are in business and you're going to learn some good techniques, wherever and whatever you do, the insight what you're going to gain today will be a stand you good in whatever you do. And as much as you, I'm also looking forward to eagerly listen. And before I move on further to call the panelists, let me also firmly tell you all the events what happened. I told you, and question slips. They have also given a question slip to each one of you. If you have any questions, please answer your question to do that. Ladies and gentlemen, put your hands together to warmly welcome our distinguished panel for this evening. Justice Ramasubramaniam joined us online from New Delhi. We have General Bandari, Avinash Pradhan, Ganesh Chandru, Srikant Navle, and Bala. May I repeat, please take a place on the dais. Ladies and gentlemen, a warm round of applause to our distinguished panel, whom most of them come from Singapore only for you to share their insights. I mentioned about the format of the program. Our distinguished chief guest this evening will give a formal keynote address on the theme. Thereafter, panel discussion and Q&A. And before I call upon our distinguished chief guest for this evening, Justice retired Ramasubramaniam, former judge and Supreme Court of India. We have the privilege of introducing him, and India is boast of a distinguished legal career spanning over 23 years in High Court of Madras, graduating in chemistry from Ramakrishna Mission Vivekananda College, and later pursuing his law from Madras Law College. He was enrolled as a member of Bar in 1983 with the experts on the top practices in notable tenures. His journey exemplifies unwavering dedication to justice and rule of law. I can tell you, ladies and gentlemen, each one of you are here, each one of you are watching it online. You are blessed to be here this evening to listen to Justice Ramasubramaniam. Now I request Justice Ramasubramaniam, please deliver the keynote address. Over to you, sir. Justice Ramasubramaniam.
Thank you, Group Captain J. Kumar. The President of the Madras Management Association, the other office bearers of MMA, the partners of Raja and Tan, respected speakers and panelists, distinguished invitees, a very good evening to all of you. At the outset, I apologize for my inability to be physically present. The pleasure of addressing an audience live is lost for me today. There is one more aspect. The opportunity to address an audience physically gives the sadistic pleasure of violating the human rights of a few, which I miss today. I do not know
Ladies and gentlemen, I think technology is so good sometimes happens. Very rarely it happens. This happened today. But you'll be joining us any moment now. Till then, a lot of new people who have come for the first time. Let me tell you what's about MMA. MMA is established in 1956. We've got over 8,500 members. We do some 150 events in a year. And we have a great infrastructure which you are here today. We've got about 24,000 square foot. We've got phenomenal car parking, state-of-the-art library, and multiple classrooms. And you must come and use our library. The library got 1.25 million books which can be referred and used, research papers. We've got a lot of e-books. Besides that, we do a lot of unique programs, number of workshops, certificate courses, and many things. But one thing, we also do some training for IAS preliminary and IAS advanced courses. So that will be a full-fledged course we conduct. And one advantage of this, you do the course, I think you get also diploma in management. I think I said maybe I'll request the distinguished panel. I take this time to introduce our panels. By the time Justice will join us, let me introduce the privilege of introducing Jainil Bhandari. Jainil Bhandari is a partner, Raja & Sons Singapore, and he's also a director of Raja & Sons Myanmar with legal experience since 1989. He specializes in shipping and trading disputes, international commodity contracts, and offshore construction projects. A qualified arbitrator and fellow of the Chartered Institute of Arbitrators. Jainil is also recognized as a global leader in shipping law and has been consistently ranked as chamber and the Legal 500 and other prestigious publications. We also have with us very warm welcome to Jainil. It's a pleasure and really appreciate your support to MMA in bringing this great event today. Then we also have Avinash Pradhan. Avinash Pradhan is the Deputy Head of International Arbitration and Company, Head of the South Asia Desk and Raja & Sons Singapore LLP, and recognized for his advocacy, skill and expertise in international arbitration. He specializes in commercial disputes across sectors like banking, M&A, and construction. Avinash is accredited specialist in building and construction law and acknowledged by who is who and legal ALB, Asian Rising Star, and Legal 500 for his exceptional abilities. Let me have the privilege of introducing Ganesh Chandru, partner Duva Associates. Ganesh is a partner Duva Associates India, specialized in international and domestic arbitration, commercial litigation, and ADR. A fellow of the Chartered Institute of Arbitration UK and Singapore Institute of Arbitrators. He is appointed by the Government of India to be the India's International Arbitrator Center and has served as a counsel and assistant registrar of SIAC and recognized globally. Ganesh is listed as Who is Who Legal Arbitrators of 2024 and Forbes Legal Power of 2021 and his expertise in arbitration and mediation. Very warm welcome to you, Mr. Ganesh. Let me have the privilege to introduce another distinguished panelist for this evening is Srikanth Navle. Srikanth Navle is an independent arbitrator and also Singapore with Shimma ADR India. Specializing in ADR, he handles arbitrators across various sectors including trade, service, aviation, and healthcare. And with a unique blend of legal, financial, business, and expertise, Srikanth is also a fellow of the Chartered Institute of Arbitrators and serves in the panel of ICAR, IA, and AACs. Very warm welcome to you, Mr. Navle. It's a pleasure to have you with us. We also have with us Mr. Bala. Bala is the Deputy Head of Shipping, International Trade Partner, Raja & Sons Singapore. Bala is the Deputy Head of Shipping, International Trade, and partner of Raja & Sons Singapore. Trained as a marine engineer, he specializes in shipping, energy, offshore, international trade disputes, recognized by the best lawyers as Asia Law and is a Chamber of Asia Pacific. Bala is an accredited specialist in maritime and shipping law by Singapore Academy of Law and speaks on global conferences across in all international conferences. Ladies and gentlemen, once again a very warm round of applause for distinguished, really outstanding panel this evening. I will now kill our. I think Justice will be joining us any moment. There's some power issue in Delhi. I think election is happening, so there has to be a power issue. And I request.
I have joined. I have joined.
Oh, Justice joined. Sir, over to you, sir.
I'm so sorry.
No, sir, no issue, sir. It's perfectly okay.
I'm so sorry. Actually, Delhi is a place, according to me, of power and pollution. So whether there is pollution cut or not, there is always power cut in Delhi. And I do not know whether to thank the organizers or not for inviting me to deliver the keynote address before the special session. The special session, as all of you know, is on arbitration, the nuts and bolts, and I do not know under which category they have placed me. To begin with, I must congratulate the Madras Management Association for joining hands with Raja and Chan of Singapore for hosting an event of this nature in Chennai. As a lawyer who practiced entirely in Chennai and as a person who spent 10 years of my judicial career in Madras High Court, I was always flabbergasted by one paradox, and it is this. Tamil Nadu has always been one of the favored destinations of foreign investments. Therefore, one would have expected Chennai to be one of the top destinations for arbitrations also. But ironically, while the flight of capital is towards southern part of India, the flight of arbitration is towards north of India. Therefore, I am glad that the MMA thought fit to bring one of Asia's top law firms to Chennai. I do not know how many of you are aware of the fact that Raja and Chan are placed 19th among the world's best firms in the field of cross-border restructuring and insolvency work, and for the 6th consecutive time, they featured in Global Restructuring Review's prestigious top 30 list of standout firms. It was highlighted in Global Restructuring Review that Raja and Chan's winning streak continued from 2018 in GRR 30. In fact, the current Chief Justice of the Supreme Court of Singapore was the managing partner of Raja and Chan. Therefore, MMA has done well to join hands with them for hosting this seminar. Like Raja and Chan, MMA also has a glorious past. Established in 1956, MMA is one of India's foremost management associations, winning the Best Local Management Association Award continuously for the past 12 years. They also deserve our appreciation for this initiative. Dear friends, today India has become one of the fastest growing economies in the world. The IMF Executive Director was quoted by CNBC on March 1, 2024 as saying, I quote, "If you look at the GDP numbers, India is poised for about 8% growth this year. That makes India easily the fastest growing economy in the world. You look at the statistics regarding capital flow into India, especially since 1991, shows that the economy has grown by leaps and bounds. Total FDI inflows into the country from April 2000 to December 2023 was $971.521 billion. Out of this, the total FDI inflows received from April 2014 to December 2023 constituted about $448 billion US. Mauritius constitutes 26%, Singapore contributes 23%, USA 9%, Netherlands 7%, and Japan 6%. All these countries emerged as top 5 countries for FDI equity inflows into India for the year 2023-24. History shows that many times the flow of capital is followed either by aggression or by litigation. India is no exception to this general rule. After our economy opened up in 1991, India entered into a series of bilateral investment treaties. By the year 2015, India had signed 83 BITs and several international investment agreements. The first ever BIT was with the United Kingdom in 1994. In the year 2003, India developed its own model BIT. The first 10 years from 1994 to 2004 perhaps proved to be a period of honeymoon between the Republic of India and the investors. But the honeymoon ended in 2004 with the initiation of the first round of BIT arbitration in 2004 in the Dabhol power plant case. Planned as a joint venture between the Maharashtra Power Development Corporation, Enron, General Electric and Bechtel, Dabhol Power Corporation aimed to set up a huge naphtha-based plant in the first phase and another huge gas-based plant in the second phase. As the largest foreign investment in the country at that time, Enron was given top priority in terms of clearances. But the power purchase agreement between Enron and the Maharashtra State Electricity Board was kept under the wraps. Therefore, the party in opposition at that time promised to throw the project into the Arabian Sea once they came to power. When they came to power, it was revealed that Maharashtra State Electricity Utility was paying 7 rupees 80 paise per unit to buy power from Enron, while charging retail consumers 1 rupee 89 paise per unit. By contrast, the cost of power purchased from the other producers like the National Thermal Power Corporation and the Bombay Suburban Electric Supply varied from 80 paise to 3 rupees per unit, in contrast to 7 rupee 80 paise per unit being paid to Enron. Therefore, this created a huge furore. At around the same time, something was happening in the US. Enron was found guilty of a huge accounting and corporate fraud. Therefore, it went into bankruptcy. The agreement was terminated. However, the other investors like Bechtel and the General Electric brought claims against India under the India-Mauritius BIT, alleging expropriation of their interest in the power plant by the Indian government. The claims were, however, settled and India had to compensate for the losses. After Dabhol came the second most important BIT arbitration case involving the Australian company White Industries. In 1989, the Australian company entered into a contract with Coal India Limited. Though the contract was governed by Indian law, the contract specifically excluded the operation of the Indian Arbitration Act 1940, which was the law at that time. But it contained an arbitration clause requiring the parties to arbitrate all disputes under the ICC arbitration rules. Therefore, when the disputes arose, they were referred to an ICC tribunal in June 1999. An award was passed in 2002. The award was challenged before the Calcutta High Court. The Australian company filed an application before the Delhi High Court to enforce the award. The Australian company moved an application first for transfer of the Section 34 petition from the Calcutta High Court to the Delhi High Court. Thereafter, they moved the Calcutta High Court itself for rejection of the application to set aside the award. The Calcutta High Court dismissed the application for rejection of the petition under Section 34. The division bench confirmed it. The Australian company filed an appeal in the Supreme Court. The appeal was referred in the year 2002 to a larger bench. 9 years passed. Therefore, in the year 2009, contending that the inability of the Indian courts to enforce an award for a period of almost 7 to 9 years, tantamount to a breach of Articles 3, 4, 7 and 9 of the BIT, the Australian company launched a claim for a sum of Australian dollars 10 million upon the Republic of India. As there was no response from the Indian government, the Australian company invoked Article 12, which provided for the reference of the dispute to an ad hoc tribunal constituted under the arbitration rules of INCITRAL. Before the arbitral tribunal, the Australian company advanced two arguments. One related to the violation of what is known as FET, Fair and Equitable Treatment Clause, under Article 3, Subclause 2. It was contended by the Australian company that the entertainment by an Indian court of an application to set aside the award and the shocking delay on the part of the Indian courts in dealing with the application for enforcement of the award amounted to denial of justice, and as a consequence, it violated the FET standard, Fair and Equitable Treatment Standard. The second important contention of the Australian company was that the Indian court's delay of 9 years in enabling them to enforce an international arbitration award was directly attributable to the failure of the country to provide effective means of asserting and enforcing the rights under the award, and that therefore it constituted a breach of Article 4.2 of the BIT. Interestingly, Article 4.2 of the BIT between India and Australia did not contain a clause for the provision of effective means of asserting claims and the enforcement of rights. But the Australian company drew parallel from Article 4.5 of the agreement between the Republic of India and the state of Kuwait, and contended that there was an obligation on the part of the Republic of India to treat investments made in its territory on a basis no less favorable than those accorded to investments of investors of any third country. In other words, they claimed that the investments of all countries deserved equal treatment. Interestingly, the arbitral tribunal rejected the claim of breach of Article 3.2, that is FET standard, which revolved around the failure of the Indian courts to dispose of the matter. But the tribunal upheld the contention revolving around Article 4.2, and the tribunal said, I quote, Indian judicial system's inability to deal with White Industries' jurisdictional claim in over 9 years and the Supreme Court's inability to hear White Industries' jurisdictional appeal for over 5 years amounts to undue delay and constitutes a breach of India's voluntarily assumed obligation of providing White Industries with effective means of asserting claims and enforcing rights. After this White Industries case, there has been several BIT arbitrations involving the Republic of India, such as Louis Dreyfus Armateers, then this was under the India-France BIT, then Deutsche Telekom versus Republic of India under the India-Germany BIT, Kadamat Integrated Solutions Private Limited versus Kingdom of Saudi Arabia under the India-Saudi Arabia Treaty, etc. Then came the Vodafone arbitration case. It became a classic case for the nuances that it threw up. The original arbitration was under the India-Netherlands Treaty. While the arbitration was pending, Vodafone filed another investment arbitration under the India-UK BIT against the retrospective effect of an amendment made by the Indian government under Section 9(1) and Section 195 of the Income Tax Act 1961, read with Section 119 of the Finance Act 2012. The Indian government approached the Delhi High Court seeking an anti-arbitration injunction against Vodafone for initiating two parallel arbitral proceedings, one under the India-Netherlands Treaty and another under the India-UK Treaty. But in the year 2018, the Delhi High Court rejected the contentions of the Republic of India, upholding the principle of competence, and held that the purview of intervention with the BIT arbitration is very limited, and the provisions of the Arbitration Act will not apply to BIT arbitrations. The year 2019 also saw some relevant investor-state disputes. Khaitan Holdings Mauritius issued a notice of dispute to the Republic of India under the India-Mauritius BIT. The Republic of India moved before the Delhi High Court seeking an anti-arbitration injunction, but the Delhi High Court, relying upon Vodafone, rejected the application for injunctions. Another interesting set of investment arbitrations took place in Nissan Motor Company case, where parent equitable treatment clause came to be evaluated by the Permanent Court of Arbitration, Singapore. The arbitration was under the India-Japan Economic Partnership Agreement against the non-payment of unpaid incentives under the Indian tax regime. Republic of India's objection to the jurisdiction of the PCA Singapore was eventually rejected. The fallout of these spate of arbitrations, actually as of 2015, there were about 17 known BIT claims against India. So the fallout of these spate of arbitrations was an increased national concern. Therefore, between 2012 and 2016, India revisited its BIT regime, which led to two main outcomes. The first was the adoption of a new model BIT in December 2015 with the twin objects of affording, one, appropriate protection to foreign investors in India, and number two, while maintaining a balance between investors' rights and the government's obligations. The objective was to terminate the old BITs where initial duration had concluded, or the issuance of joint interpretative notes statements for renegotiation on the basis of the model BIT, where the BIT's initial term was still in continuance. Since 2016, India has terminated 77 bilateral investment treaties. It has entered into several new generation BITs with states such as Belarus, Brazil, Taiwan, Kyrgyzstan, etc. In May 2022, India entered into a Comprehensive Economic Partnership Agreement, CEPA, with the United Arab Emirates and India-Australia Economic Cooperation for Trade Agreement, ECTA, with Australia on 29th December 2022. The Model BIT 2016, as we know it now, consisted of 38 articles and 7 chapters. It seeks to enhance the bargaining power of the state. The Model BIT has adopted what is called the Salini criteria, as was held in a landmark case between Salini and the Kingdom of Morocco. This Salini test is a test employed by tribunals to define the term investment in Article 25(1) of ICSID Convention. To pass this Salini test, the investment should satisfy 4 criteria, namely 1, a contribution, number 2, a certain duration, number 3, a risk, number 4, a contribution to the economic development of the host state. The model BIT has made an exclusion of pre-investment activities from the purview of investments and has removed the MFN clause, most favored nation clause. Another clause which has come under criticism is Article 15.2 of the model BIT, which requires that an investor has to necessarily seek legal remedy from the domestic courts of a host state for an initial period of 5 years before seeking a claim under the model BIT. Model BIT 2016 has also evolved a differentiation between direct and indirect expropriations. Dear friends, India's model BIT came under serious criticism on the ground that it is host state centric. Some critics have said that after India's actions post 2016, the flow of FDI into India has declined. But there are others who say that it has not. In the budget speech of 2024-25, the Union Finance Minister said, I quote, "The FDI inflow during 2014-23 was $596 billion, which is twice the inflow during 2005 to 2014. I unquote. Interestingly, the Finance Minister gave a different connotation to the acronym FDI. We all think FDI is foreign direct investment. The Finance Minister said in her budget speech that the acronym FDI should henceforth stand for First Develop India. That should be FDI, is what the Finance Minister said. Dear friends, there are 3 areas which continue to pose serious challenges to the BIT arbitration regime. They are public health, human rights, and environment. When arbitral awards touch a raw nerve on these 3 areas, there is a big hue and cry that these are instruments of domination by the powerful against the democratic will of the people, which leads to unacceptable discrimination between nationals and aliens, blackmailing of governments by multinationals, and the protection of polluting industries causing harm to environment. This is the theory that is advanced by the opponents of this regime insofar as the areas of public health and environment are concerned. Therefore, the investors, the lawyers in the arbitration circuit, and the arbitrators have a duty to strike a balance. I do not know how many of you have heard about Mr. Samuel Gompers, a Jewish immigrant trade union leader. He founded the American Federation of Labor. Of course, in the context of mandatory arbitration clauses in employment contracts, Samuel Gompers said something very interesting. It goes as follows. He said, "Do I believe in arbitration? Yes, I do. But not in the arbitration between the lion and the lamb, in which the lamb is in the morning found inside the lion." I unquote. Though he said it in the context of arbitration between workers and managements, the same should not be allowed to be said of investment arbitrations also. Therefore, with these few words, I take pleasure in welcoming Raja Khan and the MMDA for organizing the seminar on a topic of seminal importance. I hope the participants will hugely benefit from the knowledge that is shared by persons carrying a lot of expertise in this field. Thank you very much.
Thank you, Justice, for inspiring and thought-provoking address. I'm sure you'll be staying here for some time. It'll be a nice thing. And ladies and gentlemen, a warm round for Justice for delivering a keynote address. This is the tone for the discussion to come. Now, I request Avinash Srikanth to take it forward. You will be moderating. Who will you know? Jain, please. Yeah, special session. Mr. Jain. Thank you. Yeah. Justice Ramasubramanian, Captain Vijay Kumar, distinguished guests, a very good evening to all of you, and thank you very much for taking the time to come today for this event that we have organized together with the MMA. And today's event, we have actually put together a short presentation and a panel discussion about why international arbitration is the preferred mode of dispute resolution for cross-border disputes. So we take the position in this event that where you have cross-border disputes, that is meaning where you have an Indian party that is involved in a dispute with an overseas party, instead of litigating it in court, whether it's the Indian court or the courts of the overseas country, you should instead go for arbitration. And today we will explore why that is the preferred option by just giving you some key basic concepts, some key pieces of information which you can take away, and hopefully you are then convinced that you should put arbitration clauses in your commercial contracts instead of litigating in court. So today, there are 4 areas that we will deal with in the presentation, and then we'll have a panel discussion where we will delve more deeply into some interesting issues that arise in an arbitration and in the enforcement of an award that is the culmination of the arbitration. And that will be followed by a Q&A session where you can raise any questions that you like, obviously concerning the topics that we have raised today, right, to the panel. Right. So we'll first start off with a brief introduction, and then we'll talk about key concepts and advantages of arbitration. And then we will deal with some key features of the SIAC rules or the SIAC rules. Some of you may be familiar with SIAC, which is Singapore, which is it's an arbitration institution in Singapore, the Singapore International Arbitration Center. And lastly, we will give you some tips on drafting an arbitration clause. Right. So let me just start off with a very basic question of what is arbitration. And essentially, it is a consensual dispute resolution process, which is based on the parties' agreement to submit their disputes for resolution to an arbitral tribunal. So it's actually a private hearing, and the foundation of the arbitration is the parties' agreement to refer the dispute, whether it's to one arbitrator or 3 arbitrators. So the process is based on an agreement, and the agreement, the arbitration agreement, must be in writing, and it is usually contained in the contract that is entered into between the parties. And the key feature in arbitration is that it's flexible. It is for the parties to agree on
the form of procedure they wish to adopt. No specific rules of evidence apply. And this is actually something that the parties have adopted and agreed to adopt. So there is therefore that flexibility that's worked into it. And the result, which is extremely important to the parties, is the award. And in an arbitration, and we will explain why as we go along, the award itself is a final decision that is legally binding, and it cannot be easily unwound, whether by the court of receipt or the court of enforcement. That is the basic premise of an arbitration. Now, the process itself in an arbitration is similar to a court hearing in that there is a procedure for the parties to present their cases. And quite typically, the way the procedure works, both for court and arbitral process, is that you have initial documents that are filed which sets out your case, which puts out your arguments, where you present your evidence, and then after that there is an oral hearing where witnesses are called in course of judging, and then there is closing submissions, and then you have an arbitration award. Now, in an arbitration process, typically, because of the flexibility, there are no rules of court that apply, and because of the flexibility, you can take two approaches. You can take either what we call the pleadings approach, which is similar to court proceedings, where parties put in case statements. You put in a claim statement where you set out the main facts relied on, you attach the documents to the claim statements, and then the other side puts in a defense, or if there's a counterclaim, puts in a counterclaim, then there is a reply and a defense to counterclaim, etc. And then the evidence comes later. So the evidence itself that you rely on, witness statements, experts' reports, etc., is not attached to the pleadings. So that is what we call the pleadings approach. But in an arbitration, you can also take a memorial approach, which is where the parties will set out their entire case, all your documents, all your legal submissions, all the evidence that you rely on, which means your factual witness statements, your experts' reports, everything is put into the documents that are initially filed. So when a claimant puts his memorial forward, he's putting out his entire case, which the defendant then looks at, or the respondent looks at, and then responds accordingly with his entire case. So the stages are sort of cut short. Now, you can argue which is the better method, right? Those that prefer the pleadings approach say that it's better for parties to put in the case stage by stage, so that we can then consider the case, and then we can, if we think that they have a stronger case, then we can, negotiate a settlement before the costs run up too high. Because with a memorial approach, you have to kind of front load your case. You front load your costs because your entire case is put forward right at the start. So sometimes parties don't like that kind of approach. But again, it just illustrates the flexibility of an arbitral process. Now, why arbitration over court proceedings? Basically, three key reasons. First, arbitrations are generally a faster process. Because if it's governed by certain rules, for example, if it's the SIAC rules, once the hearing is concluded, the tribunal has to come up with an award within 3 months. And typically, because you don't have formal rules of evidence applicable, you don't have all these applications that come in, that kind of prolong the court proceedings, for example, the process moves very swiftly. And typically, within 6 to 12 months of starting the arbitration, you can get an award. So that's one key benefit. Secondly, costs. There is greater recoverability of costs in an arbitration. When we talk of recoverability of costs, what we mean is that the winning party, whether it's in court or arbitral proceedings, will usually get an order of costs in its favor. But in court proceedings, most national courts, and this is true of Singapore, Malaysia, and I believe also in India, most national courts will not award the winning party 100% of the cost that it has incurred. So if you have incurred $100,000 to bring a case right to its conclusion, whether it's court proceedings or arbitration, you have incurred $100,000. The order for cost that you may get if you win from court may be 20%, 30%, 40% of $100,000. That's all you will get. But in an arbitration, you almost always recover your cost in full, unless it is shown to be very unreasonable. So that is one key advantage of arbitration over litigation, in that the successful party can recover almost all its legal costs in the award from the unsuccessful party. And lastly, it is because it's a flexible procedure and it's a more informal procedure, it's not in front of a judge or in front of a courtroom. The process is simpler, more convenient for the parties, less intimidating for witnesses, and also the formal rules of evidence don't apply. What are the other advantages of arbitration? Why do parties want to arbitrate? There's privacy and confidentiality. Court hearings are open hearings. You go to open court, anybody can walk in, they can listen, reporters can come in, they can report the case in the press, right? So that is something that parties may not want. They want to preserve the confidentiality of their agreements, the confidentiality of the dispute. So they opt for arbitration because it's a private thing. That's the first thing. Secondly, neutrality of the forum. You can choose your forum. You can decide, right, that if I'm contracting, say, with a Chinese counterparty or a Taiwanese counterparty, right, or a Emirati counterparty, let's say, I can decide whether I want to put the forum for the arbitration in, say, Singapore or Hong Kong or Dubai. The choice is mine, right? So the parties like that. Thirdly, as I mentioned, procedural flexibility that you have in arbitration. You're not bound by rules of court. There is a procedure, it is agreed, but it's less formal. Next, potential finality of an award. There is no appeal on the merits. You can only set it aside on very limited grounds. My colleague Avinash will expand on that course of this presentation, right? International enforcement, meaning to say, unlike a judgment which may not be recognized in a foreign court, an arbitration award, by virtue of the fact most countries have become signatories to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, it is enforceable in a convention country. So there are more than 100 over countries that have ratified the convention, and it simply means that if you contract with a counterparty who is from a convention country, an award that is obtained against that counterparty can be enforced in that country. Of course, there is a process that you need to go through, but it's a relatively simple process, and it is relatively easy to enforce the award as opposed to a judgment which may not even be recognized by the courts of that foreign country. So, international enforcement. And lastly, expertise. Why? When we say expertise, the arbitration process is favored by various sectors and industries simply because you can choose an arbitrator with the specialized knowledge that is required for that particular industry or sector. So, when we look at contracts typically with arbitration clauses, they cover various diverse sectors. You will see it in manufacturing contracts, which are really usually cross-border contracts, right? So a lot of such contracts would have an arbitration clause. Secondly, you see arbitration clauses in technology contracts, because technology disputes are highly technical and complex. And in such contracts, if you have an arbitration clause, you can choose a tribunal who has the required knowledge to understand the dispute, to understand the issues, and to arrive at the correct decision. So you see that in technology contracts. Thirdly, very common to have arbitration clauses in logistics contracts and also in commodities contracts. Now, in commodities contracts, we're talking basically of sale and purchase of both hard and soft commodities. And you can have various kinds of disputes: quality disputes, quantity disputes, non-delivery, force majeure. And for a lot of these contracts, for many years, they have been subject to arbitration. And you have trade associations like GAFTA, FOSFA, FORA, which have their own rules of arbitration. So the parties are familiar with the process. They are familiar with the rules of arbitration, and they opt to put an arbitration clause in their contracts. And lastly, where it is very common to have arbitration is in shipping or maritime contracts. Now, again, because shipping is multi-jurisdictional, you will see arbitration clauses invariably in various types of shipping contracts. For example, charter parties, contracts of affreightment, sale and purchase, ship sale and purchase agreements, shipbuilding contracts, ship repair contracts, etc. And this has also been the position for many, many years. And for a lot of these shipping-based contracts, for a long time, most of them provided for London arbitration. And London arbitration under the rules of the London Maritime Arbitration Association. But that has changed over the last 10, 15 years. We've seen a shift of disputes coming towards Singapore, Hong Kong, and lately Singapore has already surpassed Hong Kong in terms of the number of disputes that have come in. And so for maritime arbitration, we have a Singapore Chamber of Maritime Arbitration in Singapore, which is an arbitration institution that was established specifically to serve the maritime community. So it was actually set up after taking feedback from various shipping industry players. And the feedback that was received was that the shipping industry preferred to have a simpler way of resolving disputes as opposed to a typical institutional arbitration where you have the institution like, for example, ICC or LCIA or SIAC, where they actually play an active role in the administration of the arbitration, where they charge an administration fee which can be rather high. So the maritime community said basically that we don't want this kind of procedure in our arbitration. We want a simpler procedure. We want something that is not quite ad hoc, but not institutional. So as a result of that, the SCMA was formed, and the SCMA offers what we call a self-administered arbitration model, which is like a hybrid between ad hoc and institutional arbitration. It's ad hoc in the sense that the Secretariat does not get involved in the conduct of the proceedings. It does not get involved in the scrutiny of the award, and its fees are very reasonable, right? So in that sense, it is ad hoc, but it's still institutional because there is a framework. There are rules that apply. So if you go for SCMA arbitration, you need to adopt the SCMA rules. So the SCMA rules, they are designed along LMA rules, but with some modifications. So these rules will apply from the time that you start the arbitration until the award is made. And there is specific rules govern each step of the process and also provide for the tribunal's powers to act. And the good thing about the SCMA rules is that there is also an expedited procedure that's available. So this expedited procedure applies for disputes up to $300,000. But the parties can opt to agree to adopt the expedited procedure even if the disputes are of higher sum. And sometimes parties do that, or the parties agree to have it on a documents-only basis to expedite the process. And the thing about the expedited procedure is that the timelines are shorter under the rules for you to submit your case statement, defense, etc. And the award must be rendered within 21 days of the last submission that goes in. So typically within 3, 4, sometimes 5 months you will get an award. So it's a very fast process, and that's the advantage of the SCMA rules. But again, that's something that the community wanted, and we have that in place in Singapore, and now we're seeing increasingly more maritime arbitrations going towards SCMA. And lastly, of course, there is a panel of arbitrators, specialists, maritime or shipping arbitrators, who either come from industry or are lawyers with the relevant expertise in that sector. Right, so for the next part of this presentation onward, I will ask my colleague Avinash, who has got experience with construction and projects, and to take it forward. Thank you.
Thank you, Janil. Good evening, everyone. It's very nice to be speaking to you this evening. It's a pleasure to be here in Chennai. I'm just going to carry on from what Janil was discussing. So he had left you, I think, with talking about sector-specific arbitration. And one sector in which arbitration is particularly important is the construction and projects sector. Fundamentally, that's because, putting aside the amounts of money at stake and the nature, the capital-intensive nature of such projects, the reason why it's so important is because you really need a specialist to deal with a construction dispute. Let me explain why. And perhaps in these terms might be particularly interesting to you. There was a study done on judges. And this was in the context of judges making decisions in respect of criminals who were pleading guilty to their crimes. And the question that the researchers were doing were they were asking themselves, how do judges react to sentencing depending on what they were eating? Okay? What they were eating. And it was found that when the judges had eaten, they were more forgiving. So the criminals who got the best sentences were the ones who were sentenced just after lunch or just before breakfast. Okay. Now that's I tell you that story because the point it illustrates is that judges are human beings. Now all human beings are fallible and all human beings get tired. If a person is not a specialist in something, most judges are highly intelligent individuals. If you're not a specialist in something though, the problem is when you have to decide something you're not familiar with, you take a long time to educate yourself about that subject matter. Now in something like a construction dispute where it gets very complicated, if a lot of time is spent and energy is spent in learning about the subject matter, then the effort that you take to do that is going to eat up your energy in terms of deciding the bit that is really important to the parties. So what I've just said applies to all that Janil said, and this is one of the great advantages of arbitration. With a good arbitral institution, what a good arbitral institution does is it selects an arbitrator that knows the subject matter very, very well. So in a construction dispute, and construction disputes are very close to my heart. As it says on the slide, I'm an accredited specialist in construction law. But in a construction dispute, having an arbitrator whom you don't need to explain things like a critical path analysis to is a tremendous advantage. Now, I'm going to move on to the key concepts in arbitration. And the first thing I want to talk about is something called the law of the seat of arbitration. Now, what is that? Now, if you think about it, ultimately, what is arbitration about? It is a mechanism that prevents the parties from going to court, right? It stops the parties from going to court. But an arbitration cannot exist independent of any judicial or legal system, right? Because ultimately, the reason parties go to arbitration is because they have a dispute, a claim, and at the end of the claim, you need a result, and you need to be able to take that result and go somewhere and get someone to enforce it so you actually get paid, right? Otherwise, there's no point to doing it. The law of the seat is fundamentally important because it operates as a bridge between the agreement to arbitrate and the powers of the judicial and legal systems around the world, so that whatever you have consented to in the arbitration for an arbitrator to decide something has effect, has legal status. The seat is the key concept in doing that, the seat of the arbitration. Now, what it does is it first determines the procedural law of the arbitration. The second thing it does is it designates the courts. It designates the courts which have something called supervisory jurisdiction over the arbitration. Now, the courts that have supervisory jurisdiction, what they do is they fill in holes or gaps in relation to the arbitration, which means that the arbitration can get to a conclusion. So say, for example, the parties are unable to agree on an arbitrator, and the mechanism for agreeing to the arbitrator doesn't provide the result, saying there's no arbitral institution that is designated by the parties. The supervisory courts will then appoint the arbitrator if the parties cannot agree. Similarly, if there is a challenge to the arbitrators because one party says they are impartial, the supervisory court provides an avenue for that challenge. Supervisory courts deal with interim measures, and supervisory courts deal with challenges to awards. The third point with respect to the law of the seat is it determines the nationality of the award for the purposes of enforcement. Now, why is that important? Like I said, the seat is the thing that bridges the parties' consent to arbitration to the coercive powers of the courts. Jainil mentioned the New York Convention on Enforcement of Arbitral Awards. In order to take the benefit of the New York Convention, your award needs to be seated. The law of the seat must be a convention country for it to take effect.